Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. So, tonight's lecture is going to be on Chapter 4, and we are going to be covering inchoate offenses and parties to crimes. We're going to take an in-depth look on three specific categories: criminal attempt, what that really is, conspiracy, and solicitation. And then we'll see how the parties to a crime piece fits into what we're discussing. So let's go ahead and jump right into tonight's lecture. So by way of introduction, in 2014, Gilberto Valle was convicted in federal court of conspiracy to commit kidnapping and the unauthorized use of the National Crime Information Center, NCIC. It's a database commonly used by officers to run people's names and get information. But this really isn't an ordinary case of kidnapping, and you'll come to see how his conviction wouldn't survive this legal review at the end. So Valle was a New York City police officer, husband, father of an infant, and he was convicted of planning to rape, torture, and eat women. And yes, I said eat. The plan victims include his wife, who was to be bound, have her throat cut, and slowly bled to death. Now, when she discovered his plans, which were largely developed with his conspirators, if you will, via the internet, she immediately fled the home and contacted police. Now, Valle was later arrested and his computer searched, and what authorities found was pretty sickening and shocking. So police uncovered his research online and his discussions about how to abduct, rape, and murder women, including details about two possible victims. And Valle had a handwritten document entitled Abducting and Cooking Women, a Blueprint. And he used the NCIC system to obtain personal information about his intended victims. And in one case, he traveled to meet one of them. Now, one of the intended victims was a 3-year-old stepdaughter of one of his co-conspirators, Michael Van Hise, who wrote that he was raising his stepdaughter until she was old enough to be raped and killed by hanging. And Van Hise also offered his nieces up as victims to his co-conspirators. So Valle wrote about another potential victim, saying that he wanted her to experience being cooked alive, that she would be basically made up like a turkey, terrified and screaming. Now, at the end of this all here, no murders, rapes, or kidnappings occurred before the men were arrested. As such, federal prosecutors charged Valle with conspiracy to violate federal statutes that prohibited interstate kidnapping and with illegal use of the NCIC database to obtain information about his victims. Now, Valle, commonly referred to as the cannibal cop by the news media, defended against the charges by alleging that he was only engaged in fantasy and that he had no real intention of following through on the plans. Now, to support his claim, he pointed out that he had not taken any serious steps towards the commission of the kidnappings. But federal prosecutors countered, basically saying that his act of using the NCI system to research his victims, traveling to meet one, his research into methods to drug and abduct people, his basically creation of the blueprint document, and his communication of details on how to abduct, murder, and eat specific victims were sufficient acts to prove conspiracy. So at the end of the day, the jury agreed, and he was convicted of both conspiracy and misuse of the NCIC, and it was life in prison for the first part and 1 year in prison for the NCIC. Now, the kidnapping conviction, however, was overturned in 2014 by a federal district judge who held that Valley didn't go far enough in the commission of the kidnapping to be guilty of conspiracy. In his opinion, and the judge wrote this, the evidentiary record is such that it is more likely than not that the case that all of Valley's internet communications about kidnaps are fantasies or role play. And despite the highly disturbing nature of Valley's deviant and depraved sexual interests, his chats and emails about these interests are not sufficient, standing alone, to make out the elements of conspiracy to commit kidnapping. So the NCIC misuse case was left intact, and the other case was basically dropped. He ended up getting time served while he was awaiting trial. Excuse me. So this cannibal cop case, if you will, really does illustrate how hard it can be to draw the line between thought and action. And in criminal law, the distinction between the two manifests itself in many ways. And one way is in the laws of conspiracy and what we call inchoate crimes. Or, well, we'll define what that is in a minute. So, what is an inchoate crime? Well, they are crimes that are what we call incipient or initial stage crimes, which generally lead to other crimes. And inchoate means imperfect or partial or unfinished. And in some cases, they are referred to as anticipatory offenses. And they include, or traditionally include, attempts, solicitation, and conspiracies. Now, while language favoring punishment of inchoate misconduct can be found in 14th century judicial opinions, most of these inchoate crimes were not recognized until the late 18th century. Until then, prevailing legal wisdom often held that a miss basically is as good as a mile. And these were things that were prosecuted. Now, a conceptual difficulty with inchoate crimes is that the earlier the police intervene to arrest someone for a crime, the greater the possibility that the person will be arrested for conduct that may appear suspicious, but may actually be innocent. Now, on the other hand, the longer the police abstain from intervening in what may be a planned crime, the greater the likelihood the crime will be successfully completed and the victims will be harmed. Further, if completed crimes could not be punished, police would have no incentive to stop acts of violence and other crimes before they are completed. So again, if uncompleted crimes could not be punished, then police really would kind of say, well, why should we worry about those? So again, inchoate crimes are often referred to as anticipatory offenses. And we talked about the fact that if uncompleted crimes couldn't be punished, then police really have no big time motivation or incentive to stop acts of violence and other crimes before they actually occur. So the Model Penal Code defines attempt as a specific intent crime. And the defendant must have the commission of a specific crime as a purpose. So there are basically two general elements of an attempt. The first one is specific intent or purpose to commit an offense. And the second is a substantial step undertaken toward the commission of the offense. Now remember, we're talking about attempt. Now in California, the statute on criminal attempts provides a person commits an attempt when, with the intent to commit a specific offense, he does any act which constitutes a substantial step towards the commission of the offense. And there are other states that basically do the same thing. So let me make sure I get here. Okay, so almost any crime can be attempted. And as such, every statute defining a crime also creates the crime of attempt. So stay with me here. Some crimes have their own section for attempt. Others have a code that defines attempt. So I'll give you a couple examples from California. So attempted burglary, the burglary section is 459 PC. It's the penal code. And the attempt section is 664. So if we were going to do attempted burglary, it would be 664-459 PC. So that would be attempt. Now, some codes are made to where the attempt is actually just one section. So if we look at attempt arson, it would be 455 of the penal code. So there's, again, it kind of depends how that falls, but some crimes have their own section for attempt. Others have a code that defines the attempt. And these are a couple of examples, if you will, from California. So staying with criminal attempt, we'll talk about the act requirement. So as I stated, almost any crime that can be envisioned can be attempted. And as such, nearly every statute defining a crime also creates the crime of attempt. Now, for Florida law, for example, says that a person who attempts to commit an offense prohibited by law, and in such an attempt does any act towards the commission of the offense, but fails in the preparation or is intercepted or prevented in the execution thereof, commits the offense of criminal attempt. So you can see some of the differences. So the act requirement for an attempt to be charged, an act of some sort is necessary. Now, if you recall from the earlier discussion of actus reus, that thoughts and ideas are not acts, and as such may not be the actus reus of a crime. So imagine oneself stealing, raping, or murdering another is not unlawful. Historically, evil thoughts were rarely known in the law. However, the advent of the internet and social media has enabled the immediate and often indiscreet, as well as the widespread communication of what had historically been private thoughts. The result of this has been more prosecutions for threat and attempted crimes, pushing courts to refine what qualifies as an act or a threat. And in some cases, the line is held by the First Amendment's free speech guarantee, and in others, it is the policy objective of criminalizing bad actions, not bad thoughts. So again, courts have held that mere preparation to commit an offense is not sufficient to support a charge of attempted criminal activity, and that some specific action must be taken toward the actual completion of the intended offense. And that brings us to what we call preparation. But there is a zone between thinking about committing a crime and successfully committing the crime. Is it possible to plan and to take steps toward the crime without completing it? And as so, such attempts may be criminalized. So for an attempt to be charged, again, an act of some sort is necessary. And we just talked about how the fact mere preparation to commit an offense is not sufficient to support a charge of attempted criminal activity. So when we talk about preparation, the model penal code, again, requires what we call a substantial step toward the commission of the offense. Mere preparation, again, to commit a crime is generally insufficient to constitute the crime of attempt. Could could mere preparation to a certain point maybe become a conspiracy? That's possible, but we're talking now. Remember, we're talking about attempt, okay? And just a little bit more information. The U.S. Court of Appeals for the Fifth Circuit in Mims versus United States observed that much ink has been split in an attempt to arrive at a satisfactory standard for telling where preparation ends and attempt begins. And in the often cited case of People versus Rizzo, 4 defendants were cruising the streets of New York searching for a victim they knew as Charles Rowe. And Rowe was a payroll clerk, and the defendants felt certain that he would be walking from a bank carrying a deposit bag, which they thought would be full of money to meet the upcoming payroll for the company where Rowe worked. Now, one of the defendants, Charles Rizzo, told the others that he would be able to identify Rowe and would point him out to them before the robbery. And although the defendants never found Rowe, their suspicious activity attracted the attention of police. Now, they were arrested and charged with attempted robbery. And at trial, all 4 defendants were convicted of attempted first-degree robbery and sentenced to prison. Now, Rizzo appealed his conviction, arguing that he had not legally attempted the crime of robbery because he never came close enough to carrying out the offense. And the New York Court of Appeals agreed and reversed his conviction. And the appellate court based its decision on part on the earlier court's findings, basically talking about acts constituting an attempt, are those that come very near to accomplishing the crime. So hopefully that kind of makes a little bit of sense. But we know that mere preparation to commit a crime is generally not sufficient to constitute an attempt. So, and again, courts have used different formulas in distinguishing between preparation and substantial step. One of those is what they call the last act test, which asks whether the conduct completed is dangerously close to completing the crime itself. And this is talking a little bit about what we call the proximity approach. And the proximity approach was the traditional test used at common law. And under this approach, again, acts remotely leading towards the commission of the offense are not considered as attempts to commit the crime, but acts immediately connected with it are. And that proximity test was based on the last act test. So the notion that the more serious the threatened harm, the more justified the court would be in examining acts further back in a series of acts that would lead to crime completion. So the idea that the clearer the intent to commit the offense is, the less proximate the acts need to be to the completion of the crime to constitute the crime of attempt. And that brings us to something, again, that we just kind of talked about briefly, which was the proximity approach. Acts remotely leading towards the commission of the offense are not considered as attempts to commit the crime, but acts immediately connected with it are. And again, this is based on that last act test. And this test asks whether the accused had taken the last step or act towards the commission of the offense, had performed all that he or she intended and was able to do in an attempt to commit the crime, but for some reason did not complete the crime. And again, this test was replaced with what we call the physical proximity test. And we'll talk about that one now. So the last act test was replaced with the physical proximity test in most jurisdictions. And under the physical proximity test, the substantial test or the substantial step need not be the last act, but it must approach sufficiently near to it in order to stand as a substantial step in the direction of movement towards the intended crime. So by definition requires that the accused has it within his or her power to complete the crime almost immediately. So that brings us then to the dangerous proximity test. So the law further evolved when Justice Oliver Wendell Holmes developed what we know now as the dangerous proximity test. And this test incorporates the physical proximity standard, but is a little bit more flexible. So according to the dangerous proximity test, a person is guilty of an attempt when his or her conduct is what we call dangerously close, or within dangerous proximity to success. And according to Holmes, courts should consider three factors: the nearness of completion, the degree of intended harm, and the degree of apprehension felt by the intended victim. So that's the dangerously close test. Now, still under attempt, the model penal code approach incorporates aspects of both the proximity test and the unequivocal test. And under this test, an attempt will be found to have occurred in many cases where the defendant does not move very far along the path towards consummation of the intended offense. So as we're talking a little bit more about criminal attempt, is there a way, or is there a defense to charges of criminal attempt? Well, during the Vietnam conflict, Father Philip Berrigan and another prisoner in a federal correctional institution were charged with attempting to violate a federal statute prohibiting the sending of letters in and out of a federal institution without the warden's consent. And both were apprehended as they attempted to mail these letters. Now, in presenting evidence in the case, the assistant U.S. attorney established that, unknown to the defendants, the warden had been aware that the letters were being prepared and were about to be sent. And apparently the warden let the conduct leading up to the actual mailing of the letters occur in order to help the government build a stronger case against the defendants. Now, in this situation, Father Berrigan clearly did all that he intended to do in order to commit the targeted crime. He was convicted by a trial court of an attempt violation, but his conviction was overturned by a federal appellate court, which ruled that although the priest's conduct amounted to more than mere preparation, it was legally impossible for him to commit the crime because the warden, in effect, consented to the conduct when he did not interfere with it. So here's kind of another twist in this whole thing relating to inchoate crimes, or in this case, attempts. But are there some defenses? Well, that's one. Well, here's another one: abandonment. And this defense claims that the defendant voluntarily decided to renounce any continued attempts to commit the crime. And a defense to a charge of attempt, it's a defense to a charge of attempted criminal activity. It's also called reunification. And virtually all jurisdictions require that the abandonment be voluntary. So the defense of abandonment claims that the defendant voluntarily decided to discontinue the attempt to commit the crime. And Indiana law says it like this: it is a defense that a person who engaged in the prohibited conduct voluntarily abandoned his effort to commit the underlying crime and voluntarily prevented its commission. So again, there are some defenses to this. Another one would be the defense of impossibility. Now, there are a couple of things, just going back really quick. There are a number of arguments in favor of allowing abandonment or reunification as a defense. And one, it encourages desistance. Two, it indicates a lack of dangerousness on the part of the offender. And three, it shows a lack of intent on the part of the defendant to carry out the crime to its completion. Now, on the other hand, critics might say that it has a little deterrent effect. It fails to show whether the defendant will prove to be dangerous in the future. And lastly, the accused has already completed the crime of attempt. So even so, courts in most American jurisdictions today recognize this defense of abandonment. Well, what about impossibility? Well, again, this is a defense to a charge of attempt. So a defense to a charge of attempted criminal activity that claims that the defendant could not have factually or legally committed the envisioned offense, even though he or she, excuse me, had been able to carry through the attempt to do so. So there's a couple of examples there when you talk about impossibility. So let's take a quick look. So, for example, to rob a person who has no possessions, even though robbery might be attempted, it is similarly impossible to kill someone who is already dead. So I mean, so there are some impossibilities. Let's look at another one. Another example of factual impossibility is that that of a pickpocket who tries to pick an empty pocket, even though the intended victim had nothing in his pockets. That person still could be charged with an attempt. And a final example might be that of a person who attempts to shoot another only to find that the gun is not loaded. So legal impossibility, a much different type of impossibility, generally precludes prosecution in most jurisdictions. The defense of legal impossibility claims that the attempted offense is really no offense at all, either because there's no law against the imagined crime or because the actions in questions do not meet the requirements of the law for a crime to have occurred. So a couple of different things, but impossibility is one. And then completed offense. Well, in most jurisdictions, if a defendant is charged with a substantive crime, but evidence indicates that the defendant only completed an attempt, he or she may be found guilty only of the lesser offense of attempt. If the crime is completed, however, then the attempt is usually considered to have been merged into the completed offense, and the defendant will be guilty only of the substantive offense and not of both the offense and the attempt. So does that kind of make sense? So again, in most jurisdictions, if a defendant is charged with a substantive crime, but evidence indicates that the defendant only completed the attempt, they may be found guilty of that lesser attempt. And the example I give is assault and battery. And these are two interesting kind of connected things. An assault is one crime, a battery is another, and is it possible to really be charged with both? Because the assault is going to be the attempt to, let's say, punch someone or throw something at somebody or what have you, and the battery is the actual striking or physical contact in there. So, think about that as we kind of continue to go through some of these different sections. Now we're going to move on to criminal conspiracy. So a criminal conspiracy is an agreement between two or more people to commit or to effect the commission of an unlawful act or to use unlawful means to accomplish an act that is not lawful. Now, many of today's conspiracy cases involve things like drug trafficking, in which there are several people that agree to work in concert or together to manufacture, transport, and or distribute controlled substances. So the commentaries on the MPC state that conspiracy is an offense has two different aspects, reflecting the different functions it serves in the legal system. In the first place, conspiracy is an inchoate crime, complementing the provisions dealing with attempt and solicitation in reaching preparatory conduct before it has matured into commission of a substantive offense. Second, it is a means of striking against the special danger incident to group activity, facilitating prosecution of the group and yielding a basis for imposing added penalties when combination is involved. Now, I know that's a lot of legalese, but part of the criminal conspiracy, again, is that agreement between two or more people to commit or to effect the commission of an unlawful act or to use the unlawful means to accomplish an act that is not lawful. And with that falling under conspiracy is what we would call the doctrine of complicity. And prosecutors pursuing conspiracy cases have available to them a number of procedural advantages that are not available in other cases. And I'll kind of walk you through a couple here. So first of all, procedural advantages favoring the prosecution include the use of joint trials, the admission of hearsay evidence, which is statements and things that are said outside of court, and the fact that the case may be tried in any jurisdiction in which the element of the offense occurred. Now, these are definitely complex, and conspiracy in itself is a complex and controversial crime, and some judges and legal scholars have advocated for its reform. Criticisms of the crime of conspiracy include charges that it provides the state with a more potent and possibly unfair weapon because it gives prosecutors extraordinary latitude in prosecuting behavior that would not otherwise be criminal. And similarly, prosecutors pursuing criminal cases, again, have available to them a number of procedural advantages that are not available in other cases. And one is hearsay evidence. And quickly, the definition of that is something that is not based on the personal knowledge of a witness. Witnesses testify, or witnesses who testify about something that they heard, for example, are offering hearsay by repeating information about a matter of which they have no direct knowledge. So you can really see how this could be an issue. And one of the more famous cases that is in your textbook on page 107 talks about the Drew Peterson murder. And this case basically is, can hearsay evidence be the primary evidence in a murder case? So I'm not going to go through the whole thing, but I would highly suggest that you read that article on the Drew Peterson case and understand the amount of hearsay evidence that was brought in to that case. It's very interesting. So we know an agreement between, criminal conspiracy, the elements of the crime. The crime of conspiracy has 4 elements: an agreement between 2 or more people, the intention to carry out an act that is unlawful or one that is lawful but is to be accomplished by unlawful means, a culpable intent on the part of the defendants, and again, depending upon jurisdiction, preparation, an overt act, or a substantial step in furtherance of the conspiracy. And I put a little chart here So when a conspiracy unfolds, the ultimate act that it aims to bring about does not have to occur for the parties to the conspiracy to be arrested. And here's kind of a cool little graphic, if you will. I don't know if I made a bigger one. Okay, here I did. We talk about the paths to guilt on a conspiracy. And this one takes you through solicitation and conspiracy as well. So take the time to look at this one, and it'll open your eyes a little bit more on conspiracy and what constitutes that. So still under the criminal conspiracy is something that we call the plurality requirement. Now, the essence of the crime of conspiracy is an agreement for the joint purpose of unlawful ends. And because conspiracy is defined in terms of an agreement, it necessarily involves two or more people. This aspect of the offense is called the plurality agreement. This requirement has both mens rea and actus reus elements. The mens rea is the conspirator's mutual intention of committing the underlying offense. The process of coming to an agreement is the part of the crime's actus reus. So again, plurality agreement, the logical and legal requirement that a conspiracy must involve two or more people. Any implied agreement is sufficient for prosecution under most conspiracy statutes. So just a couple more bits of information under plurality. And then that takes us, so we're still under criminal conspiracy, to something called Wharton's Rule. This is an agreement by two persons to commit a particular crime. Cannot be prosecuted as a conspiracy when the crime is of such a nature as to necessarily require the participation of two persons. And that's the example would be like adultery. So the rationale behind this is basically the fact that, I mean, adultery takes two people and they're both consenting. So therefore, this agreement by two persons to commit a particular crime, if adultery is a crime in the state that you're in, can't be prosecuted as a conspiracy when the crime is such a nature as it necessarily requires the participation of two individuals. And let's not forget that also under the criminal conspiracy when we talk about required intent. So as noted earlier, the essence of the crime of conspiracy is an agreement to commit an illegal activity or to commit some legal activity via illegal means. Now, accordingly, conspiracy is a specific intent crime, and someone who appears to conspire to commit a crime may not be guilty of conspiracy if intent to commit the crime is lacking. And as we read about in chapter 2, specific intent requires thoughtful, conscious intention to perform a specific act in order to achieve a particular goal. Hence, to prove the crime of conspiracy, the government is required to prove that the defendant specifically intended to effect the commission of an unlawful act. So, prosecution required to prove that the defendant specifically intended to effect the commission of an unlawful act, and an apparent co-conspirator does not need to have any criminal intent for the other party in a conspiracy to be convicted of the offense of conspiracy. Well, what about the parties then? Well, the law does not require that each party who participates in a conspiracy form an agreement with all of the other parties involved. And think about it. So examples: organized crime, drug dealing and distribution. There's a lot of players. And on page 111, it talks about the wheel conspiracy. And it also talks about the chain conspiracy. And the wheel conspiracy, the conspirators deal with only a ringleader and basically not with one another. So there are a lot of parties involved in all of these. And the chain conspiracy involves a sequence of individuals. So, there's a lot of, different types of conspiracies. And because 2 or more individuals are required to establish a conspiracy, at least 2 individuals must be convicted of this crime as well. We're going to talk about that in just a second. So, conspiracies require at least 2 individuals. So at least 2 individuals must be convicted of that crime. And that kind of makes sense. It's kind of illogical for one of the 2 conspirators to be acquitted and the second convicted. If this happens, both defendants by law must be acquitted by the court. If there are multiple defendants, however, only 2 must be convicted for the verdicts of conspiracy to be upheld. So if there's 6, but only 2 are convicted, then that's okay. But if there's only 2, 1 can't be acquitted and 1 convicted. So that's just part of the criminal conspiracy. Acts in furtherance of the conspiracy, all jurisdictions require, again, that some act in furtherance of the conspiracy occur to satisfy that actus reus requirement, and we know what that word means. In some jurisdictions, merely planning the crime satisfies that particular requirement. In other jurisdictions, the defendants must commit an overt act. Any act beyond preparation in furtherance of the commission of the crime satisfies the requirement. And then, real quick, before we jump into another thing, let's talk about the Pinkerton's rule very, very quickly. All conspirators that are liable for the acts of, or they are liable for the acts of co-conspirators that are taken in furtherance of the conspiracy. So this liability rests with all co-conspirators, even if they individually didn't authorize or were aware of the act. It applies to all overt acts. One interesting thing with conspiracy is this thing called co-conspirator hearsay rule. And again, this is still acts in furtherance of the conspiracy. This is another unique feature of conspiracy trials. And I talked about it a minute ago. Hearsay or other statements made outside of court are generally admissible in trial. But in conspiracy cases, inadmissible at trial. But in conspiracy cases, the statements of conspirators made during the planning and furtherance of the crime, they are admissible, even if those co-conspirators are not available to testify. So, a conspiracy can be said to continue until the crime it anticipates is either completed or is abandoned by all of the parties involved. And if there are multiple conspirators and a single conspirator withdraws, the conspiracy continues for the purpose of the law as long as 2 or more parties continue to be involved in it. Okay, so moving on quickly because time is limited. We'll talk a little bit about criminal solicitation, the encouraging, requesting, or commanding of another person to commit a crime. All states have codified or codified, if you will, the crime of criminal solicitation. It is not necessary that the solicitor intend that the person he or she solicits commit the crime. And here's a great case study. This is the Julia Murfed murder for hire case. It's where we have an undercover officer being solicited to basically kill this lady's husband. There's 2 videos. The first one is the actual video of a couple of meetings between the officer and Julia Murfed. And then the second one is the actual sentencing part. And I don't want to be a spoiler on that one, but I'll let you look at that one on your own. But it's a great case for solicitation. Parties to crimes. All of those who take part in the commission of a crime, including those who aid and abet and are therefore criminally liable for the offense. So, you know, kind of an interesting thing. So in 2014, Oscar Groening, who was 93 years old, was charged with 300,000 counts of accessory to murder. Now, prosecutors allege that Groening was a German SS officer who worked in the Auschwitz concentration camp. And his responsibilities included confiscating money found in the luggage of prisoners. And that money was used to fund the camps, including the systematic killings of the prisoners. And prosecutors further allege that he knew about the systematic murder of the camp prisoners. Now, while certainly unusual both in magnitude and age, this case illustrates the crime of accessory. Now, again, all those who take part in the commission of a crime, including those who aid and abet, and are therefore criminal liable for the offense. And we have some very close concepts here. Principal in the first degree, principal in the second degree, accessory before the fact, and accessory after the fact. No, in California, we cut that down just to principal and accessory, but I'm going to go through these pretty quickly. So principal in the first degree, this is a person who acts directly resulted in the criminal misconduct. The bank robber that walks into the bank with the gun, points the gun at the clerk and takes the money. A person whose act directly results in the criminal misconduct. Principal in the second degree, a person who was present at the crime scene and who aided, abetted, counseled, encouraged the principal. So, it can be a little confusing, but just kind of hang with me. Accessory before the fact, a person who aids and abets in preparation for the crime commission, but who was not present at the crime scene. So this is someone that helps prepare. Accessory after the fact, a person who did not participate in the crime, but who furnished post-crime assistance to keep the offender from being detected or from being arrested. Now, in California, again, it's different. And we'll talk about this relationship of complicity. This is a trend in modern American law that has been to eliminate distinctions between principals and accessories before the fact. Most jurisdictions no longer distinguish principal in the first degree and second degree and accessory before and after the fact. As I stated, California has principal and accessory. And it's just like that. There's a diagram on page 114 in your textbook that gives you a little bit more information on that. And they recognize, accessory only as one who assists the felon after the crime has been committed. And an accessory is liable for separate, lesser offenses following a crime. Well, what about the accomplice? And we'll talk about the accomplice liability. So generally, one who assists in the commission of a crime but does not commit the actus reus is called an accomplice. And these are folks that are often present or directly aid in the commission of the crime. And the relationship between the person who commits the crime and his or her accomplice is one, again, of what they call complicity. And that is involvement in crime as either a principal or an accomplice. And the term also refers to the activities of conspirators, and that may therefore be taken to mean the conduct that is intended to encourage or aid another person to commit a crime or to escape prosecution, etc. And still under accomplice liability, principle that any individual who aids, abets, encourages, or assists another person to commit a crime should share in the criminal liability that occurs under the law. So they are going to be held responsible as well. What about like a lookout or something like that? Now, still under accessory, proving an accessory's guilt requires the showing that, one, a crime was committed, and two, the defendant knew that the crime had been committed. So you have to know those two pieces to make that accessory thing fit. Proving an accessory's guilt, again, requires a showing that the defendant knew that the crime was committed by the individual who was being assisted, and the assistance was personally given by the defendant to the individual who committed that crime. Now, finally, we'll talk about the criminal liability of corporations. Corporate criminal liability has evolved to include all types of offenses, including traditional crimes against the person, such as battery or even murder. And some U.S. jurisdictions take the approach that a corporation may be held criminally liable for crimes committed by any employee who has been given the power and duty or responsibility and authority to act on behalf of the corporation. And the collective knowledge doctrine imputes to a corporation the knowledge of all employees, thereby imposing liability on companies even when no single employee has sufficient knowledge to be liable. And that brings us to our last point that we'll talk about, which is called vicarious liability. And this imposes criminal liability on one party for the criminal acts of another party. So corporate liability, which you just learned about, is a form of vicarious liability because through the doctrine, a corporation or its officers may be criminally liable for the conduct of its employees. Now, vicarious liability is not limited to corporate settings. An automobile owner may be criminally liable for the acts of an individual whom she lends her automobile to. And parents are sometimes liable for the actions of their children. So, for example, a person who loans a vehicle to an individual who parks it in a fire zone may be responsible for paying the fine associated with the legal parking. Now, that's kind of a low-level concept, but at least I think it gets the point across. So, again, it's not, this vicarious thing is not limited to corporate settings alone. And punishing the vicarious liable persons who are liable may be punished in the same manner and to the same extent as the individual who committed the act leading to the liability. So corporations can be convicted of committing virtually any crime, but they can't be imprisoned. But they can be fined in order to pay restitution in order to do or not do something. So that was a quick run through chapter 4. Again, talking about criminal liability and inchoate offenses and parties to the crime. Don't forget to look at the summary section at the end of your chapter and also take a look at the key terms, because again, those will help you be very successful as we move through some of the remaining chapters. So with that said, this will be the end of the chapter 4 lecture. Until next time.